In this episode, we're going to start looking at the importance of the Supreme Court. Now, the Supreme Court is the judicial branch of our federal government. It is their job to interpret laws. Today, there are 9 justices that make up the court. We call them justices, not judges. They are appointed by the president, but have to be confirmed by the Senate. And the reason behind that is that they serve a life term. So for a president, it's very important to be able to kind of leave a legacy. That Supreme Court justice is going to be on the bench a lot longer than a president is going to be in the White House. Now, only certain cases can be heard by the Supreme Court. There's 2 different versions of their jurisdiction. Original jurisdiction is the first, and these are cases that go straight to the Supreme Court. Very, very, very few cases go straight to the Supreme Court. And they're disputes between states. Let's say Georgia and Florida are disputing water rights. That would go straight to the Supreme Court. Also, if there's disputes between ambassadors are representatives of other nations or people that we send to other nations as our ambassador or our representative. So that too is one of the only times the Supreme Court will be having original jurisdiction. Most of the cases, the vast majority, over 90%, are of what are called appellate jurisdiction. These are cases that have been appealed from lower courts. And they can be both state and federal courts. They can be both civil and criminal cases. It doesn't matter. They're always, though, from a lower court. This is the kicker, though. Just because members of the court, the justices, if they see something they don't agree at a lower court, they can't just butt in and say, oh, we need to fix this. That's not how it works. The Supreme Court justices have to wait for the case to be brought to them on appeal. It has to work its way through all the lower courts first. They can't just jump in and pluck one out that they want to look at. What the process starts with is called a writ of certiorari. And literally thousands of these come in every year. The court, though, is looking for certain criteria. They want cases of national significance. They want cases where there's a conflict amongst the lower courts, and that way they can come in and settle it for certain. And they're also looking at cases that can set precedent, that are going to be important and are going to be seen later on. This is the kicker, though. All those thousands of petitions, the justices and their helpers, which are called clerks, have to read all of them. The vast majority of the time spent by a Supreme Court justice isn't so much in court, it's reading all these writs. Now, when the justices see one that they think they might like and think that might meet their criteria, they use the rule of 4. If 4 out of the 9 justices think that the case is important, it makes it onto the next level. That next level is called the cert pool. And the number of cases gets narrowed down significantly. Out of that pool, somewhere between 75 to 100 get chosen and put on the docket. The docket is like a calendar of cases that the Supreme Court is going to hear that year. Now, when your case gets chosen, you need to start writing what are called briefs. Of course, all the transcripts, all the paperwork from the case from the lower courts have already been sent to the Supreme Court. But once that happens, each lawyer, we have a petitioner, that's the lawyer who wanted the case to be heard, and a respondent, who's the other half. This can be the government in a criminal trial, or it could be another person in a civil trial. They have to write a brief, which is a summary of the case, basically laying out their argument in writing. Now, if the government is involved, the head government lawyer is called the Solicitor General. And they're going to add a brief as well. Even if they're not involved, they can still add a brief if it's something the government wants to do. Now, these briefs have to be shorter than all the paperwork that's already come to the Supreme Court. It has to be a maximum of 50 pages. But still, that's a lot of writing. In addition to the petitioner and the respondent, we can also have what's called an amicus curiae brief. And this is just a group usually that isn't directly involved, but they want to add input. They have a vested interest in the constitutional issue that is being discussed. So, for example, let's say that it is a case on the Second Amendment and gun rights. A gun owners organization that's not really directly tied with the case, but wants to see gun rights expanded, they might file one of these amicus curiae briefs. Up next, we have what are called oral arguments. Each case is given an hour for these arguments in front of the justices. Half an hour is given to each side, and the court sees 2 different cases in a day. The petitioner gets to go first, then the respondent, and it's just the lawyers that are talking. No witnesses at all, just the lawyers. Most of the time, though, is spent with the lawyer standing in front of the 9 justices, and they're getting grilled by the judges. The justices are asking them basically any questions they had after reading the briefs and going through all the court transcripts. So really, it's more like, imagine these, kind of bossy judges all in black grilling you about your writing. If the government is involved, it's the Solicitor General that argues the case in front of the court. Here's the kicker as well. There are no cameras at all allowed in the court, but it is open to the public, so you could actually go and watch the Supreme Court in action. Once the case has been heard, the justices meet in what's called a justices' conference. They have a special conference room. That's what you see in the picture. And they're going to vote on the case. Only justices are allowed in the room. No secretaries, no bailiffs, no court officials, no clerks, nobody. Just the 9 justices. And they actually take turns talking about the case, what they think, and how they vote. And it goes by rank. Now, the Chief Justice is in charge of the court. And after the Chief Justice, we have a rank by seniority. How long have you been on the court? Once they've casted all their votes, we end up with a majority and a minority. The majority is, out of those 9, how many voted yes or how many voted no. So whoever wins is called the majority. They appoint 1 justice to write that opinion for the court. Usually it's the Chief Justice if the Chief Justice voted with a majority. And then the senior-most member who has dissenting opinion, that they were in the minority, they write a dissenting opinion. If a justice is on the side of the majority but really wants to have their own version of the opinion, they can write what's called a concurring opinion. In addition to coming up and voting on the actual cases, the justices are going to meet in this conference as well to discuss those new petitions of certiorari that are constantly coming in, hundreds and hundreds at a time. Once they have made their decision, the court usually waits until the very last day of their term. They usually take all summer off. So they start hearing cases in like October, and they end at the end of June, early July. And then they have like July, August, September off. And they're going to wait until the very end, and then they start announcing a bunch of court cases all at once. They can be released sooner if the court chooses to. This usually happens if the court, like the whole court, all 9 justices unanimously agree on a case, which isn't very often. So before it can be released to the public, the majority all must agree on the actual opinion that's being written. Okay, that's it for now.